Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Welcome back, everybody, to episode 3 of Stephen's Squibs, monthly CLE family law, case law update, and others. And we have a lot of fun things to talk about today. With me, my two co-hosts, Caryn Stevens, no relation. Hey, Caryn.
Good morning. Happy October.
Back at you. Can you believe it's already October 15th or sometime after?
Right. It's the season of pumpkin spice and hand sanitizer this year. So that's super exciting.
2020. And also joining us today, Gina Szapucki. Gina, how are you doing?
I'm good. Good morning, everybody.
Well, are you ready to talk about the August 2020 Family Law Florida Appellate Opinions?
Absolutely.
Yes.
Everybody should have their materials, and there is a number of new cases, and we also have 2 months of disciplinary matters, because today we're going to try to dive into some ethics hours and see what we can do. And we have a brand new feature. At the end, we will have a very special guest, a family law legend, and we get to interview this person and discuss some insights on ethics and professionalism, and it's going to be a lot of fun. So let's jump into our first case, Ortiz v. Ortiz. There's number 1 in the materials there. And this is a case for alimony, and the former husband basically argued a lack of findings. And we have right now a difference in districts of whether or not you actually have to make these findings of each statutory element, but you basically still have to make basic essential findings like net income and gross income. And those findings were lacking in Ortiz. There was not a single specific factual finding made in any of the factors. And the court found that that was reversible error, and the court's reasoning supported that its determination of the former wife's need for alimony is indiscernible on the record. So this is not, again, the individual alimony elements being considered. It's just the trial court providing enough information that you can determine how it arrived at the alimony and whether or not it abused its discretion. So that's the first alimony case. Gina, you're up for Harkness. I think this is a case you know something about.
Yes. At my prior firm, I did assist on this case during trial. This was a highly contested divorce, and this case also discusses permanent alimony. In this case, the parties were married for over 19 years. They had 3 minor children. The former husband was the primary breadwinner throughout the marriage, while the wife was a stay-at-home mom for majority of the marriage, raising the parties' 3 minor children. And throughout this litigation, the wife maintained gainful employment. During trial, the judge found that the wife did not need permanent alimony. Therefore, the judge did not even go into the husband's ability to pay. The judge determined that there was no legal basis for permanent alimony because the wife is financially sustaining herself because she received a job. During this appeal that the former wife did, what the court found is before even determining alimony, there has to be rulings of need and ability to pay. Here, the trial court erred by, even though they did the wife's need, they never did the husband's ability to pay. So the second thing that the trial court erred on is when we discuss permanent alimony, there is a rebuttable presumption that because this is a long-term marriage, permanent alimony can be awarded. So it would be the husband's burden to essentially show that permanent alimony is not needed. Here, because the trial court did not even get through the need and ability, there was no findings of this rebuttable presumption. And the third issue that the trial court erred on is once you get through that rebuttable presumption, the court never went through the wife's expenses to determine what her actual needs were that were established through the marriage. So when we discuss permanent alimony, we just have to first go through need and ability. Is this, can this be awarded? And if so, what is that person's needs?
Down to attorney's fees, case number 3, Bollinger v. Fries. Again, we're talking about lack of lack of findings in trial court judgments. This was about attorney's fees, and the court simply denied both parties' request for attorney's fees and cost without further comment. 6116, as we know, authorizes a trial court to award attorney's fees, suit money, and costs after considering the financial resources of both parties. Significantly, section 6116 sub 1 expressly requires the court to make findings requiring the parties' respective financial needs and abilities to pay. Additionally, there's a number of other factors the court could comment on, Rosen factors, that may have an impact on a fee award. In this case, the trial court made no oral findings of the parties' financial positions. And because of that, the appellate court is left in a position where it can't even review the appropriateness of the award. So in that case, the fee award was reversed. It's going to take us down to case number 4, and we're moving into enforcement world. This is the Jacobs v. Jacques case out of the 2nd. And this dealt with a contempt hearing, and there was no transcript. So it's really hard to appeal a case with no transcript because you have to show fundamental error on the face of the on the order being appealed. In the Jacobs case, former husband was supposed to make biweekly payments of $1,000 to the wife for 8 years, so $2,000 a month. The former husband argued that the contempt order itself was erroneous because it lacked any written findings that he had the present ability to pay those amounts. Again, there was no transcript, so the appellate court is left in a position that it can only review the order on appeal to ensure it contains the required written findings. If you look at Rule 12.615 D sub 1, it teaches us the order must contain a recital of the facts in which all its findings were based. So not only does an order have to have the magic words, they have the ability, but there must be actual findings of fact describing what that ability is in the face of the order. Otherwise, cases like Jacobs and many other can be used to reverse those orders pretty quickly. Caryn, I think we're in equitable distribution.
Yes, we have 2 cases this month in equitable distribution. And I always have a penchant for picking the most difficult named ones. So this is the Niederkor versus Kusilis case. And what happened in this case is something that we see in a lot of cases where there's a large sum of money sitting in a bank account somewhere, and one of the spouses accesses it during the case and utilizes it for various expenses. And there's a whole litany of case law that talks about what funds, marital funds sitting in an account can be used upon and used for during a divorce case. And every now and then you have the spouse that uses it for things that go beyond the scope of marital expenses. And that's when we get into that world of waste and dissipation. So what happened in this Niederkorn case is Mrs. Niederkorn got her hands on a bunch of money that was sitting in a marital bank account. And apparently it had come from a settlement that the former husband had gotten from his former employer or something like that. It was a pretty large sum of money. And the missus accessed the money. And during the course of the case, she utilized it on a whole bunch of expenses, including, as the appellate court noted in its opinion, $100,000 in cosmetic procedures out in Beverly Hills. She bought herself a $7,000 new dog with her new man friend. And then she did pay mortgage, HOA, utilities, car insurance, cell phone bills, and a multitude of other marital expenses. When this case went to trial, the court was obviously pretty wrapped up in the fact that Miss Niederkorn had done some probably not great things with the money. And instead of separating and parsing out what was spent on marital expenses and what was spent on the betterment of Mrs. Niederkorn, for lack of a better explanation, the court didn't do that. The court lumped everything together and said that everything that the missus had accessed during the case was all waste dissipation, and charged it against her in fashioning its equitable distribution scheme. She appealed. It went up to the 5th district, and the 5th district said you need to separate out what was spent on proper marital expenses during the course of the case and what was spent on, you know, plastic surgery and new dog with your man friend. And there was a very different, finding of fact at that point. So appellate court said, remanded it back down, said you need to figure out what's what. And then, yes, those expenses that she utilized the money on to spend for herself, absolutely waste and dissipation. But the monies that she spent on paying down mortgage and marital expenses should not have been charged against her. So the appellate court said that the lower court had erred in lumping it all together, so to speak. So I know this is something that comes up in a lot of cases when clients are like, oh, my husband took X and Y, and we really have to drill down on what it's being utilized for during a case.
So $100,000 was, I think, spent on cosmetic surgery in this case. Yeah. So the court did not find that that was for a marital purpose.
I'm going to assume that he didn't get much enjoyment out of that after this started. So, you know.
Gina, you want to talk about income?
Sure. The first case we have for income is Paul v. Paul. And what this case teaches us is that when we're calculating alimony, we have to remember to calculate each spouse's total net income. In this case, the trial court failed to include his business income as well as his Social Security. And furthermore, when you are the one that is paying alimony, here the former husband in this case was going to pay alimony, the alimony that the receiving spouse is to get, we have to be sure to include that amount when calculating child support as well.
And the next case is Crespo v. Watts, also an imputation case. This was a DOR case, and mom filled out some financial information, but of the 6-page DOR form they have you fill out, she only filled out 2 of the pages, and one of the pages was her signature. So there was really insufficient evidence whatsoever. The mom was receiving cash assistance because that's why the DOR was representing her. So there was an assumption that she was unemployed, but no evidence presented. There's a discussion in the appeal about how you impute income, and the basic building blocks is, the first 2-step process. 1, you have to decide whether the termination of employment was voluntary, and 2, whether the unemployment resulted from the parent's pursuit of her own interest or through the less than diligent and bona fide efforts to find employment. That 2-part step was never employed in Crespo. The court noted that she did not know why the mother was unemployed, that there was no evidence in the record concerning the issue, and the this was an administrative judge, imputed income to her. For these type of cases, if you don't have the appropriate income, you impute minimum wage. And without that information, you really cannot go above that. But this case cites sections outside of 61 that really deal with more DOR type cases, but the imputation still the same. Caryn?
So the next case we're still staying under income is the Waldera case. This is out of the 3rd district. And this is probably, I believe, the lengthiest opinion that came out this past month. This is almost a 9-page opinion. There was a whole slew of problems that happened in this case, and the entire final judgment was overturned. But the basis of this case is really about income of the husband, income of the wife, and everything that the trial court apparently did wrong in calculating that income. So the husband in this case was an attorney, and the wife was sort of a stay-at-home homeschooling mom pre-COVID. So kudos to her. Before it was forced on her, she was doing it. And she also would work part-time as a bookkeeper for like the husband's law firm and some other things. And she made like very minimal income. And apparently while these folks have been married and had this one child, they made this decision together, this joint marital decision that the wife was going to be the stay-at-home mom who homeschooled their child full-time. And there was a whole bunch of testimony during the case that the wife had actually spent, I don't know, upwards of, 10 hours a day doing homeschooling with this child, including her extracurriculars and all of that. And she would do a dabbling of bookkeeping in the community here and there. And this is down in Monroe County, so it was in the Keys. And what happened is when this case went up to trial, the husband had his forensic accountant, and the forensic accountant took the stand, and the forensic accountant made a whole bunch of statements to the court that were obviously ultimately rebuked on cross-examination by wife's attorney. But the husband's forensic accountant made some calculations that the wife could work 20 hours a week, making X dollars, and was imputing a huge number to this wife for her income. And the court kind of latched onto that, and the court actually made findings in its final judgment that it thought that the homeschooling was unnecessary and that the wife could go back to work. So that was issue part 1. And then issue part 2 was that the husband, of course, like so many that get themselves involved in divorce proceedings, was having his worst business year ever, because we've never heard that before. But what the court did is it locked onto his income from that one particular year, refused to look back at what this man as an attorney had historically made. And they made some notes in the opinion that he made anywhere between $97,000 on his lowest year and $227,000 on his highest year. And of course, in 2016, he was in like the 50,000s. So instead of looking at past historical earnings, and I understand that that's not always what the current income was, but when you're looking at 6108, you're supposed to look at all relevant economic factors, including all sources of income and past historical earnings. And that's what the court didn't do. So the court hooked onto this low income for the husband, hooked onto a high income for the wife, made a decision that this child didn't need to be homeschooled anymore, and overrode this joint marital decision, and basically awarded the wife like nominal, like $1,000 a month in alimony, and said she could make a whole lot more. And what was interesting is the appellate court engaged in a long discussion about how the court should really take great deference into decisions of the parties made during the marriage. And it went on to say that if a couple makes a decision that their children are going to stay home and be homeschooled, and that was what they did for years, like the Walderas had done, that far be it from the court to come in and say, nope, you don't get to do that anymore because I don't think it's right. So that was an interesting finding that I don't think I've seen in any case or a lot of cases before. And obviously the fact that the wife's income wasn't based on any substantial competent evidence, it was based on husband's forensic accountant coming in and saying, this is what I got. This is what I used, and the court hooking on to that, even though on cross he admitted he had never met with the wife, he had never looked at any jobs in the community or anything like that. And then the appellate court also said that the lower court abused its discretion in how it determined the husband's income, and it should have looked at his historical earnings, not just this little tiny picture of what was going on in this one bad year. So long explanation, but long case.
Sticking with income, the next case involves a professional athlete, Gore v. Smith. It's case number 10 in the materials. And Frank Gore is a professional NFL player and had a child back in 2008 squared up with a paternity action with mom. Problem is, there was no child support guidelines filed. There was no evidence of Mr. Gore's then income. So when mom came back a decade later and tried to modify support up, one of the issues was there a substantial change of income? Mr. Gore, when he signed this agreement, didn't have any net assets. During the modification, he had accumulated about $17 million in just under a decade. So it appears that he was doing financially very successful, but how do you figure out that issue? In this case, the wife, or the mother, not the wife, but mom, did not have any of dad's financial disclosure from early in his NFL career. So the forensic accountant got kind of creative and was affirmed for this approach. He re-engineered the dad's income by using the child support guidelines. He took the base amount, plugged in what mom was, and kind of like algebra, out popped a number of what dad's income would be to reach that child support number. Now, dad got appealed that methodology and said, whoa, Florida law says you have to figure out my income by taking the gross, taking out the deductions, reaching the net, and that's how you have to determine this number. The accountant's methodology was affirmed because the court realized that figuring out the income for 2008 was not determining income for the purposes of child support. It was determining whether the income to determine whether or not a substantial change of circumstances happened. So a very interesting, unique case. And it also mentions good fortune, child support. So those dealing with really high income folks, you want to be aware of the Gore case. I think that takes us down to 11. Let me try to get this right. Szapucki.
It was a valiant attempt.
I put effort into that. Versus Marenko. This was it's a case we've already talked about, where the court put a negative number for income on rental income because it was going at a loss. The holding is basically the same, but the court granted rehearing and replaced the opinion. But apparently you can still reduce your income from real estate rental losses. And this is a really good case for that. In our previous episode, we discussed that, it was pretty much common practice just to put a 0 as opposed to a negative number on that line in the financial affidavit. That takes us through the income cases.
All right, and we're moving on to injunctions. On the first injunction case, there was a bunch this last month. We'll go through several of them, but the first one is Berkeley v. Roy. This is a case out of the first district, and the petitioner had sought a stalking injunction. So the petitioner in this case was Ms. Roy, and the respondent was Mr. Berkeley, and Ms. Roy was seeking the stalking injunction against Mr. Berkeley. Both were pro se, like so often happens in these cases, and they showed up for their properly noticed domestic violence hearing, and the court swore them both in. The court asked 2 questions to the petitioner and asked just a couple more to the respondent, and then entered a permanent injunction for stalking against Mr. Berkeley, despite the fact that in those couple of questions the court asked him, he said, "Hey, Your Honor, I've got documents, evidence, videotape, and a bunch of witnesses in the hallway ready to testify." The court just kind of moved past that, had a super brief hearing, and entered a final stalking injunction against Mr. Berkeley. He appealed, got himself a lawyer this time, and the appellate court said there was all sorts of due process issues because he wasn't given an opportunity to have a proper evidentiary hearing. There was no cross-examination that he was able to conduct on the petitioner, and he was denied, basically just fully denied his ability to present his case. So that was reversed and remanded back to the lower court, and the lower court was told to have a proper hearing.
The next case in the materials, number 13, is Sweet v. Taylor. And this is someone trying to dissolve an injunction years after it was entered. It was originally entered in 1998. And the respondent or the appellant took a very novel approach. 20 years later, he says, when I was served, I was 17. Therefore, the court lacked personal jurisdiction over me. Never raised this issue in the many years, and he participated in the injunction hearing, and he filed motions afterwards. His argument was rejected by the first DCA, who reasoned even if the original service of process upon the respondent was defective, that it was undisputed that he had notice of the proceedings against him. So the injunction was voidable, not void. And because Mr. Sweet, the respondent, participated in the hearing, he exercised, he made himself available to the jurisdiction also by filing those motions. He cited to one case that suggested it should be voided, but the appellate court said that there is a reasonable diligence in moving to set aside is a factor, and waiting 18 years just basically blocked the respondent from doing anything. We're going to jump down a case now, 15. This may not be the case, but this will be the issue of the year because this deals with attorney professionalism and attorney discipline, and also a reversed cyberstalking injunction. And it was between two attorneys, Ashley Krapix and Nisha Bacchus, down in South Florida. But it's a fourth DCA case. The case originally arose from the appellant's own DV case with her boyfriend, and the appellee or the petitioner in the injunction represented the boyfriend in that DV petition. Well, things spiraled out of control. The Miss Krapix started posting things on the internet. There was one incident where she went on a 4-hour spree of tagging Miss Bacchus in a number of Instagram posts. And there's a cute little footnote at the end of the case that actually describes what tagging is. So for your folks that don't know, tagging.
Welcome to 2020.
I'm assuming some people know and some people don't know, but you got to get on that IG, folks. Tagging occurs when a person A uses person's B username to link their post to person's B's account. This makes the post visible to person B's social media contacts and creates a direct hyperlink between person A's post and person B's account. So by tagging person B, you're connecting your social media and the content of your post to their social media. Now, the appellate court was concerned about this one 4-hour incident, and there were other things going on, blog post, insults, derogatory statements, and the attorney who is the victim of this, like there was a post describing what kind of car the victim drove. So the victim testified that she was worried that her car was disclosed because she could not understand how the attorney discovered that personal detail. She felt extremely anxious when she found out. Apparently, the attorney was also reaching out to her former clients and seeing if they wanted to file a bar complaint and offered to represent them for free. That's not in the appeal, but if you read the disciplinary report that came out, we'll talk about that in a second. There's a lot more facts in the disciplinary report than in the opinion about the unprofessionalism between these two attorneys. The appellate court, the trial court entered the injunction. The appellate court reversed it and said, well, maybe that 4-hour period was problematic, but it's really one occurrence and the statute requires 2 occurrences. So we find that that is not sufficient enough. So in this case, this injunction, which also prevented, because the 2 attorneys worked in the same building, it said the attorney could only go to her office once a week. And it also prohibited a prior restraint on anything that may be constitutionally protected speech. And all of this is discussed. So the injunction was reversed, but there's also a second footnote in the case. And this appeal was released the same month that the attorney was disbarred. And we'll talk about that disciplinary action when we get to that section. But because of this unprofessional conduct, it led to the attorney being disbarred. So for the injunction, it wasn't sufficient. But if you're an attorney, you certainly have to understand your duty to act professional and other consequences besides just an injunction. The Supreme Court took that very seriously. You'll see the referee recommended a 3-year suspension. The Florida Supreme Court said no. This rises to the level of disbarment.
It's a hard case to read. I think the appellate court did the right thing, but it's a hard case to read what was going on, especially between 2 attorneys and being the victim of that. But anyway,
let's talk about something better. Yes, modifications.
Let's change gears. Let's get out of that heavy stuff for a minute. So we're going to talk about modifications.
Disbarment to modification in one case.
Here we go. So I have there's 2 cases this month of modification. I'm going to cover them both real quickly for us. But the first one is Miller versus Miller. This is a case out of the 5th DCA. This was a post-divorce case, not a post-paternity, but a post-divorce case. 2 kids. Dad was a military dad. And in fact, when they got divorced, mom lived in Florida. Dad lived and was stationed in California. And in fact, they note in the appellate opinion that when these 2 folks got divorced, they entered into an agreed upon expansive parenting plan that was divided into 3 parts. And apparently these folks really put a lot of effort into trying to figure out what was going to be best for their children, who were super, super, super young, not even school age when they did split ways and get divorced. And they were doing a rotating time sharing schedule with 3 weeks in California with dad and 3 weeks with mom in Florida because the kids were not in school yet. And as life happens, kids are getting ready to go to school and they turn that older age. And these folks had agreed in this expansive parenting plan that before their oldest child started kindergarten and formal schooling, they were going to go back to mediation and figure out where they should go to school, where they should live, and all of that sort of thing. So they went to mediation, didn't work out. Dad files a modification action because now, on top of everything with these kids starting school, Dad's getting stationed in Japan. So that's a pretty significant change in the lives of these folks. And interestingly enough, when they entered into this expansive parenting plan, they agreed at the time that there'd be no direct child support paid from one parent to the other because both of them were self-sufficient, both could support their children, and they both were doing 50-50 time sharing. So there was an agreement to no child support, which was ratified by the trial court at the time. And so that was how they lived their lives for the next several years. When Dad filed this petition for modification, he was arguing the kids should go to Japan with him. Mom, of course, counter petitioned and said, no, kids should stay in Florida with me. And oh, by the way, also court, it was, quote, an oversight that there was no child support established when the trial court did our original divorce and signed off on it. So case goes to trial, court not only hears all this evidence, but what the problem was is that the trial court essentially rewrote this entire expansive parenting plan of these folks and argued and said things on the record that, quote, with a schedule that puts more responsibility on each parent for much longer periods of time, the kids are older, I feel compelled by statute now to calculate child support. So not only did the court enter all these changes on how the children were going to live, rear, and go to school, it felt, quote, compelled by statute somehow to now calculate child support. Dad argued, whoa, mom didn't plead for modification of child support properly. She didn't prove there was a substantial change in circumstances and so on. She just came in and said it was an oversight. And the appellate court agreed with Dad when he appealed it and said mom didn't meet her burden. The trial court shouldn't have done that. Oh, and by the way, courts don't just get the discretion to rework a parenting plan. And the appellate court issued a lengthy opinion and went through the different sections of this expansive parenting plan and said that these particular parts were wholly rewritten and the court shouldn't have done that. And then it found that some of the parts that the court changed and rewrote followed what was in the pleading, so they were okay with that. So they clearly defined out. But at the root of all of this is, especially with the child support, if there is no child support order to the initial action, you still have to meet the burden to come in and ask for child support later. The other case under modifications this month is the Malha versus Locialis. That was my valiant attempt, Locialis case. And this was out of the 3rd district. This is also a post-divorce case. And this involved, and I'm sure none of you have ever had this before, but this involved 2 parents who couldn't make a decision about their children. And they were fighting, of course, in this case about extracurriculars, but I'm sure we've all seen it with extracurriculars in school and a litany of other things, pediatricians and dentists. And essentially they queued up an impasse and presented it to the trial court. But what was interesting is this dad, nobody filed a modification. The dad filed a motion to compel the court to require mom to stop registering kids in travel sports, which was an interesting choice of pleadings, but that's what he filed and that's what went to trial. And essentially what he was asking the court to do was to basically stop mom from doing this and make him not have to transport the kids on his time sharing days to these sports. And these, you know, like so many parents, apparently these children were the star soccer of the world and, you know, they were going to be in the next Olympics or whatever. So they were in a million travel teams. But what the court did is the court had them come in, they did the trial, court sent them out and said, try to work this out. And of course, you know, when you're stuck in these impasse situations, a lot of times it can't be resolved because everybody's dug their feet in, came back to court, and the court essentially just resolved the stalemate and enforced the past prior decisions of these folks, which were made jointly when they enrolled the kids originally in these sports. And dad appealed and said the court modified the parenting plan. And what the appellate court said is that it was not an impermissible modification because the court essentially didn't modify anything. The court enforced a prior joint decision of the parents, resolved an impasse. And because of that, it was not a modification as the dad had argued.
All right, let's move over to some procedure cases. And if you are studying for board certification, you might want to take a look at case 20, Sanchez Vicario v. Santacano Blanche. The appellant is or was an international tennis star from Spain. They were Spanish nationals, were not U.S. citizens, but had a Florida resident, had children in Florida who went to school in Florida. And husband filed for divorce in Florida. Then he dismissed it. He also filed in Spain, but he only asked for divorce. And as soon as the wife realized he was filing for divorce, she filed for divorce in Florida, but she was served with the Spanish divorce first. So crazy fact pattern, right? But it actually has a pretty simple resolution. We're dealing with international cases, so the issues of comedy are at play. And again, if you're taking board cert, this type of a fact pattern out of a case like this, I would expect to see something like this as an essay question potentially. So despite all the jockeying around, and there's a general rule that comedy principles dictate that an action should be stayed. They were trying to dismiss the wife's or stay the wife's Florida action so the Spanish action can continue. But in Spain, the husband was only asking for a divorce. So if this motion was granted, it would have basically blocked the wife from seeking any affirmative relief whatsoever. Normally comedy says that the first filed lawsuit, not first served, but first filed lawsuit that involves substantially similar parties and substantially similar claims. And if this Spanish case had substantially similar claims, it would have been the predominant case to proceed, and the Florida case would have been dismissed or stayed. But the appellate court basically said the Spanish case was much different. He was only seeking the divorce, so the issues were not similar. So really complicated case, 6-page printed opinion, pretty simple outcome. Down to 21, which is the Constantino case, deals with an evidence motion to open for newly discovered evidence. The court did, and then changed the final judgment. It was a different judge and got reversed basically because the appellate court found that this newly discovered evidence should not have been an avenue. It would not have changed anyone's opinion. And this was really a case of the predecessor judge substituting his own opinion in place of the original judge. So that motion was denied, or excuse me, reversed. Case number 23, this is case out of Palm Beach County, Tavares v. Enoch, and illustrates the issues of having delays in final judgments. And this was an 8.5-month delay after a half-day trial. The appellate court expresses frustration and reminds us that pursuant to Florida Rule of Judicial Administration 2.250, there's a presumptive time period that these cases need to be done in 180 days, and that's from the date of filing to the final disposition, not trial date. And those are really the expectations, and whether or not we can meet those expectations, especially in high conflict cases, it's difficult, but that's still what we need to strive for. And it also stressed the importance of trial courts and their responsibility to render decisions under circumstances which give no doubt that the matter was seriously and promptly considered. Having said that, the appellate court was impressed with the 17-page final judgment because there was a lot of findings of fact that accurately recounted the evidence at trial, but the trial court made one error. It made a finding that the father had one minor criminal case before the child was born. And the undisputed evidence in the record was the father had no criminal record, and the mother admitted she was fired from a job due to an issue involving dishonesty. So the appellate court could not figure out what impact that error had on the potential decision. And because it was 9.5 months old, or 8.5 months old, the appellate court sent it back to the trial court and said, you know, this one mistake, now that you know that the evidence doesn't reflect it, does it change your mind? We don't know the answer to that, but it was remanded back. Ooh, that's procedure. Now we're going to go into support cases. First one, Reed versus DOR. And this involves what is now being called the speed credit. And that's when you have a subsequent born child and you want a credit for the child support you're paying. And it originally comes from the 1999 case Speed v. DOR on behalf of Nelson. But to be entitled to that credit, you have to actually have a formalized time sharing plan, and you have to be paying child support. This court granted the speed credit despite the fact that dad was in an intact relationship with the mother of his subsequent born child, and there was no time sharing arrangement, no child support. So under those circumstances, the speed credit was inappropriate. Caryn, you got the last case of the month.
Last case of the month, still under support, is Fernandez versus Fernandez, and this is a 3rd district case out of Miami-Dade County. Very, very interesting, not often brought up issue. This involved a 27-year-old young lady who was now an adult, who had Down syndrome since birth, had an IQ of about 60 to 70, the opinion says, and she sought dependent support from her father because she was unable to support herself, get a job, and take care of her needs. And she sought this adult child support as a dependent, in fact, under 743.07, and said that because even though she had reached the age of majority, and even though dad had paid child support since he had divorced her mother, this young lady at 27 with Down syndrome had an inability to fully support herself. She filed a petition seeking child support from her father, and the dad argued that the court lacked subject matter jurisdiction because the dad said, well, first of all, she's no longer a minor. Second of all, he said that she had not brought an action prior to her reaching the age of majority, and also argued that the original marital settlement agreement between him and her mother did not cover an extension of child support beyond the age of majority. And the Miami-Dade trial court agreed with dad, dismissed the case, and said that the court lacks subject matter jurisdiction to enter any child support orders for this 27-year-old dependent adult. Corey, the young lady who had Down syndrome, got an appellate attorney, filed an appeal, and that's what brought this opinion about. And what was interesting is the appellate court noted that even if a child or the parent of a child does not bring an action before the dependent child reaches the age of majority, and even if there is no specific reservation in a marital settlement agreement or a paternity settlement agreement for continuing child support beyond the age of majority, it doesn't matter, because there is a common law right in 743.07 and it's subsection 2 that the court always has the ability to enter child support orders requiring support for a dependent person over the age of 18 because of their mental or physical incapacity, as long as that incapacity began prior to them reaching the age of majority, which of course it was in fact with this young lady. So the the appellate court found that there was an absolute common law right vested with the court under the statute to award this dependent child support for this 27-year-old lady, and reversed the lower court's decision, remanded it back, and ordered the court to calculate child support for this young woman, and that the trial court did have subject matter jurisdiction under the statute.
26 cases. Wow. What a month.
Yeah.
What a month.
And now, a discussion of the Florida Bar's disciplinary orders since our last meeting.
We didn't talk about any of the disciplinary cases last time because we ran out of time with so much other fun things we were doing. So on page 10 of your materials, I think we have the beginning of a number of disciplinary issues for the past for the past 2 months, and we lost 5 attorneys, and 3 of the 5 were, I noticed, were attorneys less than 10 years, baby attorneys. You have case number 1, case number 3, case number 4, all people disbarred just for abandoning clients, not responding. Case number 2, Krapix, that's the one we were talking about with the cyber stalking injunction. And the report, I really don't want to go into all the things that was said because I don't want to say a whole bunch of bad words. But it's an interesting report. And the report itself from the referee is 48 pages. And again, it recommended a 3-year suspension. And when it went up to the Florida bar said, this type of professional conduct and the violations are egregious, and we're not going to stand for it. And one of the reasons the referee recommended the 3-year instead of disbarment was because Krapix had no disciplinary history whatsoever. This was the first issue. So the referee took that as a mitigating factor. But I think this demonstrates very clearly that type of behavior is going to be looked at very seriously by the Florida bar. I'm just going to go down and point out some other interesting ones. And if you guys have anything to point out, jump in. Case number 6, guy gave up his license because he was involved in a fraudulent $322 million unregistered securities offering. So don't do big scams.
And in case number 8, it doesn't matter how many times we hear this and how many times you're taught this, you can't write estate planning documents, make yourself the sole beneficiary of things. So that another attorney got disciplined for doing that again with an elderly client. So I feel like I learned that back in law school, like first day when we were talking about professional responsibility, but hey, it can't hurt to try, right? I guess.
Good reminders that these things are still happening, and that's why we are taking a look at them. Let me go back to 7. Someone got caught for scheming court-ordered sales of real property and pled guilty to grand theft. So because that involved dishonesty, he lost his license as well. Disciplinary revocation is tantamount to disbarment. In case number 9, someone let their foreclosure defense go on by paralegals without supervision. And then if you don't cooperate with the Florida bar in their investigation, that's always a big negative. Case number 11, Ms. Altman was suspended for 3 years. Made misrepresentations, but she also had been disciplined 4 times. So your history of discipline is a aggravating factor to the discipline that's actually handed out. Number 13, someone was suspended for 90 days because he notarized his own signature as his client. So you can't do that. That's a big no-no. His trust account was also messy, but no client funds were endangered. He got off with a 90-day suspension. Case number 18, 30-day suspension, DUI, property damage, personal injury, and possession of heroin. So this guy was suspended and thrown into the FLA program and also put on probation for however the Florida Lawyers Assistance Program contract was active.
And in case 19, this gentleman was running for judge, and he made a bunch of misrepresented facts during a debate when he was debating during his run for circuit judge. So
yeah, he also said he was a Republican, right? He also said he was affiliated with the political party he was speaking to.
Yes.
So I
Yes,
wasn't
correct.
trying to disparage a party. It was just a statement of
I was
fact.
just checking there, but no, nonetheless. So
There's nothing wrong with being a Republican. You can't be running for a judge and say you're a Republican in front of the Republican Executive Committee. That's all I'm saying.
you have to be a nonpartisan runner. So Mr. Decker made some bad statements in his debate, and he was did not become judge, and also was suspended for 30 days.
Well, excellent wrap up, guys. I appreciate you helping me with these cases. And now we have a very special guest. Before we get to our surprise legend, we're going to have a board certification tip.
Stephen Squibs presents this month's board certification tip.
Good afternoon, everybody. This is the part of our CLE where we have a board certification tip. And today we have one of the four who passed the 2020 board cert exam, Andrew Lieberman. Andrew, are you here?
I'm here.
Andrew, thank you for joining us today, and congratulations on passing this year.
Thank you.
Andrew, you have been an attorney since 2007. What made you decide to sit for the family law board cert test?
So ever since I started my own firm and started focusing on family law, I think it was about 2012, and I knew there was a certification. I knew that's what I wanted to do. I wanted to be board certified and specialize in marital and family law.
And when you decided to take the test and take the plunge, what did you do to start to get ready for that?
So the first time I applied was back in 2018 for the 19 test, but then my wife was pregnant and we had the baby on the day of certification review. So I made the decision to push the test to the next year, 2020. So it gave me a little bit of an advantage that I knew I was going to be admitted, or I was going to be approved. And so the tip I would say is start early, give yourself a really long runway, because I hadn't taken a test since 2007, and here I am in 2019, 2020 preparing for a test. So I started in September, and just looking at the materials, looking at what was there, and figuring out how am I going to understand all of the material in a way that it could be remembered. That took itself a long time. And so I want to make sure if I start in September, I had time for a wasted day, or it wasn't a big deal if I thought I didn't make progress that day, because I always had all these months ahead of time. And so I think that was very helpful to me. It also, I spread out the studying too. I was studying 1 day a week. So on the weekend from 9 to 5, I would go in and study.
How many hours do you think you put in studying for this test?
Over 200. I wish that I billed it like I just so I knew exactly. But keeping track of time, I think, would help too, because people told me you should study 125 hours. And I guess when I knew I was studying, when I got close to 100 or 125, I kind of felt that gave me an advantage. Like, at least I put the work in, or I knew I was around in the ballpark.
So after studying for 2 years for this test, going into it, did you feel comfortable that you were going to pass? It wasn't 2 years.
It wasn't 2 years. I put it off, so I knew I was going to get approved. So before I started.
And when you say approved, that means approved for clearance to sit for the test. Yes. And you pass peer review and they check all your credentials. It doesn't mean you're board certified. It just means if you pass the test, you'll become board certified.
Right. So I knew I still had to fill out the short form, but nothing changed. So I knew I'd be approved. So I think that was a little bit of an advantage, because people don't get approved to take the test until usually early January. So if you start in early January, I think you're at a disadvantage.
Or some people don't even know they've passed clearance when they take the test, and they take the test conditionally, which would terrify me.
Right. Put all that studying in, that wouldn't be fun. So I really studied from September of 2019 through March of 2020.
So not only studying, but get the app in early so you get that clearance as quickly as possible.
I would say as you're applying at that same time, you should be looking at what materials you need to read and review.
And they tell you the subjects, they give you the core subjects, they give you the subcourse subjects. And do you think you have to know everything in those categories?
Yes, I think that the subcore topic there was listed military, and that happened to be an essay. So do not skimp on the subcore topics.
Yes, and when I used to serve as the chair of the committee, the board cert committee, so I have many years of writing and grading that test. When you took it, did you think it was a fair test?
Yes, I think they told you everything that was going to be on there on that outline. It was extremely difficult, but it was fair. They did tell you everything was going to be on there.
And you have a couple essay questions, you have an ethics question, true and false, and multiple choice. What did you find the hardest?
The essays were by far the hardest. The first 3 essays in the morning were by far the hardest essays I've done on an exam.
Now, did you do them handwritten or did you go to the computer?
Computer.
Did most people use, when I took it, most of the people were in the room doing the blue books, but that was in 2004, before technology is what it is today. What was the percentage of people taking it on their computer?
I think everyone was on the computer.
Did you have any issues with the software that they put on your computer to lock out every other program?
So I had an issue because I guess, like I said, I deferred. So I got an email that last year. And so when I tried to sign in, I was using that email and password, and I got a little bit nervous about it. But then I found the new email. And so that was the only difficulty I had with the software. Make sure you have the right password and year and all that.
Did you take any days off before the test to lock yourself in a room and study, or?
Yeah, so I think like mid-February, I started just really focusing on the test. It was hard to concentrate on much else. And really, I think March 1st, I just told myself, I'm done. March 1st, I'm just doing the test. I'm just studying for the test. And the test is on March 13th.
Did you memorize any case names?
No.
Why not?
I didn't think the case names would matter. I thought it was the content and the substance that would matter.
They don't unless you get them wrong. So it's good not typically not to take that risk unless you're sure. But you pretty much need to know every single element of every rule and statute, don't you?
Yeah, so I memorized, I had 11 acronyms, and I couldn't find an acronym for the child time sharing factors. So I just memorized the child time sharing factors. Somehow I grouped them together, and I was really impressed that I could do that, but I didn't think that was possible. And I just want to tell you, like, if you're taking the test, I wrote all those acronyms out, and I don't know that I used all the acronyms. I don't know that I went through and wrote everything down. I really went through and analyzed everything there, and nothing I did was, exactly how I planned it would go.
Did you write your essays in a narrative form, or did you use more of an outline bullet approach?
Narrative. I did not outline.
And if you knew someone that was taking the test next year, what advice would you give them?
Like I said before, start early. The materials in the board certification review are very good. I made handwritten flashcards that really helped me remember, and it makes you think about what you put on those flashcards. I read the 2018 cases and the 2019 cases. I think maybe what was the most helpful that someone told me was the test isn't really about memorization. It's about knowing. And I think that's very true, because you can memorize all this, but they're going to give you a fact pattern. It's very difficult. And it's going to be different from what you've been doing if you're just memorizing. So I think reading those cases, if you really read the cases from the year that you're taking the test or the year before, really think about how those judges wrote those answers and how that analysis went. I think that would be very helpful.
Because the test takers don't just expect you to recite elements, they expect you to recite all of the elements and then apply them.
Right. And I think I think from my standpoint, it was more about the application than reciting the elements. I think the application was far more important.
And what did you think of the ethics question?
I thought the ethics question was simpler than the other questions. So if you want to talk about the questions, I think there's going to be, how it was for me, there's 3 questions, and whatever the topics were, they were very complex. Like, for example, for alimony, it wasn't just need and ability to pay. Very complex, very subtle. And there was 3 questions kind of like that. But then the last 2 questions, I thought the ethics question was straightforward. I don't think they're trying to trick you there. And then there's another question I thought was also straightforward. So I don't know if they intended it that way, but 3 of the essays were incredibly difficult. And then the 2 of the essays I thought were very manageable.
In the ethics essay, is it still just try to spot 10 ethical issues?
Yeah, I think so. I think you're just going through, and for our essay, they gave you this attorney who just made a lot of very bad choices, and you're just kind of calling him out on it.
Did you read any other materials other than the 2 years of cases and the red books from board cert?
The statutes. I thought the statutes were very important. I thought the statutes also were more straightforward than the materials. I think that you should start with the statutes.
Anything else you want to say to our audience about this test, taking it, or why you should take it?
Well, so if you're going to take it, I thought it was very stressful, but I didn't even want to go back in for the second half, but go back in. You can pass. It's doable. And I don't know. I'm very happy that I passed. I think it's nice to be able to say I'm board certified. I'm specialized in family law.
So it is kind of an exclusive club, and only 4 people passed, and I know a whole lot more people took it than that. So Andrew, congratulations on your achievement. We're very proud of you, and we can't wait to see what you do next.
Thank you. I just want to everyone know, like, you can study very hard. I know people study very hard and they still didn't pass. And, just make sure you study. And even if you fail, it doesn't say anything about you. You're taking this really difficult test, and just taking it, I think, is a big deal. Just taking it says something about you. Plus, it makes you a better attorney, don't you think? Oh, yeah. The studying, I learned a lot of things, how to do it the correct way. And that's I think it just helps the profession in general. Did you have a study partner, or did you do this all on your own? So I studied on my own. I never studied with somebody. I did have people that I knew that took it, and I would talk to them. And I think that was good for the psychological value, to know you're all in the same boat. You're all wondering what's going to happen. You're all stressing out, and that's very helpful. And you even talk a little bit about the topics to make sure you're on the right track also. During your break, did you talk about the first half of the test with other people? Oh, yeah, I definitely did. It made me feel better. Some people think it makes them feel worse. But, again, I didn't think that was talking about is helpful, because everybody thought the same thing. That's kind of how I felt. So it's a super hard test, but it's fair, and you need to know everything. Yes, and I think even if you know everything, you still have to know it. You have to apply it, and that's really the key. I kind of compared it to when you're giving a consultation and they're asking you all these questions. You have to know those answers. Andrew, thank you so much for your time today, and we appreciate you giving us some tips. Thank you very much.
Welcome to Steven's Sandbox, a segment where a Florida family law legend steps into the sandbox with Eddie or Caryn Stevens to discuss ethics, professionalism, their career, and staying sane in such a high conflict industry. Are you ready? It's time to step into Steven's Sandbox.
Now we have, for the first time ever, a new segment. We will be interviewing legends of family law in Florida, and our first guest is a board-certified attorney, past president of the Florida chapter of the American Academy of Matrimonial Lawyers, and he has been practicing for a very long time. Ladies and gentlemen, please welcome Andy Leinoff. Andy, how are you doing today?
I'm doing just fine. Everything is good. How are you doing, Eddie?
I am doing well, and thank you for joining us on this CLE program today and letting us pick your brain on some issues.
Well, it's my pleasure.
So you have been practicing for longer than I have. I don't want to embarrass you, but I was born in 1971, and you have
You were 3 years old. You were 3 years old when I started practicing law.
So I have about half the career that you do right now,
Right.
and I consider it a very hard, difficult thing to stay sane in such a toxic, high conflict world. And I've known you my entire career. I got to litigate with you as third chair on a case way back when, and I've gotten to litigate with you recently. And you've always had a certain sense of humor and a certain grace about how you've handled yourself in high conflict situations. How in the world have you stayed sane after so many years?
Well, I think one way to do it is you just take one day at a time. And many lawyers end up freaking out because they say they have a trial in a week, then they have another trial 2 weeks later, and they just are totally overwhelmed. And that doesn't work. And because of the fact that we've done it so long, the best approach is you just keep a routine. You try to be as prepared as you can be. You have to inject humor because most of the lawyers I deal with are devoid of humor. They're just too intense all the time. And while you should be intense, you have to break it up. And judges don't like the intensity without breaking up. And sometimes the humor is something that judges really appreciate, and they listen more carefully. You become an entertainer. You're not just a lawyer, but you now start to entertain them, and they focus more on the entertainment and they listen more carefully. So I just think that you just have to have a routine. And what I do, which most people don't do, I'm up very, very early in the morning. I start my day at about 4 in the morning, and I work until about 6 at night. I don't take too many breaks, but I stretch out the day so there's less stress, because if you have to put all your efforts into 6 or 7 or 8 hours, that is intense stress all day. When you spread it to more hours, you find that it does minimize the stress to a certain degree. So that's it. And then you just have to just realize it's still a profession. It's not the only thing in our lives. And like, I enjoy going up to Maine and kayaking. And even though I work up in Maine as well, I realize that's much more important at times than just being in a grind and just working day in and day out. So you have to keep a perspective of your life.
And you have seen many changes in the legal profession, but right now we are October 2020, and in the middle of this pandemic that seems to be affecting us and causing significant change. How are you dealing with these obstacles that are being presented?
Well, when you get to be older, the adjustments are much more difficult to accept. And I didn't know what a Zoom was 7 months ago. I had no idea. And now, of course, everything is by Zoom. And fortunately, my 2 sons who work with me have showed me how to use Zoom and what we're supposed to do. So it isn't so bad. I still have issues with introducing documents. I don't know how to do that share thing yet, but I'll learn that sooner or later because I have too many trials coming up that I have to deal with that. But you just have to adjust. I know at the beginning, I think everybody went through a lot of depression. Everybody was worried. Would they have cases anymore? Would people pay them? I was thanking people who were sending me checks in March, like I was honored because I didn't know if anybody would ever pay their bills after that. And I just think that I think almost every lawyer I know went through a lot of depression, a lot of doubt. And I think a lot of lawyers, I wouldn't say they overreacted, but they had no idea, nor did any of us, what would happen to us later on. And now things, even though we have a disaster still, most lawyers are still very, very busy. But I think it's much more difficult to settle cases now. In mediation, the Zoom is not always effective, and people can easily walk away from a mediation and not get it resolved. A lot of the hearings I have now, issues are not resolved that should be resolved. Trials are not being resolved. And I don't know if it's because of the craziness of the people or the craziness of the lawyers, or just that there's more technology and there's less human interaction between everyone. But I think in those ways, it's been much more difficult. But we can all travel. We can, if we have vacation homes or we want to go on a trip, we can just take our computers and we can Zoom, and the judges are all Zooming, and you're not restricted anymore to your office. So that at least is a benefit for now.
And you are a big fan of board certification. Can you tell us when you became board certified in marital family law and kind of how that has impacted your career?
Yeah, I became board certified, I think it was in 1988, you were 17 years old. And I became board certified, and that year when I took the exam, I think there were maybe 8 or 10 of us all together, and it was incredibly competitive, and I studied really, really hard for it. At that point, I felt really good because it's a validation. To me, with my background, I had to work very, very hard for everything that I ever accomplished. So when I got the certification, I was really, that's one of the high points of my career back then, because there were not a lot of certified lawyers. So, and a lot of lawyers initially were grandfathered in. I wasn't one of those lawyers that got grandfathered in, who didn't have to take the certification. So that was it. And that was the step that I needed to then get into the Academy of Matrimonial Lawyers, which happened the following year. So that was a very important time in my life.
And would you give, like, if you were mentoring, what tips would you give someone about board certification, or how would you tell them to approach that test?
Okay, well, first of all, even lawyers who are not, there are a lot of lawyers who are not board certified, and there are a lot of lawyers who are not in the academy who are still some of the best lawyers around. So it's not that you need to be certified to really be a great or a good lawyer, because there are a lot of lawyers who are really, really good who just don't have that, and they're doing just fine. I think that if you want to be certified, you need to be really mindful of the law, the trends of the law. You need to have a book, or you have to have all the updated cases, because certification is very big on the updated cases. And Eddie, I know you do that. You've been compiling that for years. So I think you have to read every Florida Law Weekly, make note of the cases. You don't have to memorize the names of the cases, but look at the trends. And nowadays, the trends are most telling, more so than in the past. In the past, when I first started, the opinions, there were very few reversals. There were not a lot of opinions. And basically, when a trial judge ruled, they were not caught up in technicalities like they are today with reversals. So, like, for instance, if you don't lay out all the elements of why you're awarding permanent alimony, it's going to be reversed on appeal. In the old days, you were awarded permanent alimony because there was a disparity in earnings, and it was a long-term marriage, and that was the end of it, and it was affirmed. So I think
just had to cite Canacaris, right?
Right. Yeah. So, when they talk about equitable distribution could have been anything. It just had to be equitable. It wasn't necessarily equal. So, so everybody used to cite Canacaris, and of course they misspoke the name. It was Canacaris and all the other names they used, and some forgot it. And but the judge said, well, it has to just be equitable. And so an 80-20 to me is equitable. Now you can't do that. So I think if you want to be certified, you need to make up your mind a couple of years in advance that you really need to focus on getting there, and not worry if you don't pass the exam. Just, you go in, learn the law, relax, take it, and if you don't pass it, you take it again and go from there. In fact, that's one of the only things that I have hanging on my wall from my career is my first certification. It's kind of yellowed by now. It's very yellow. I think all the print is faded off of it, but I know what it means.
I think that's probably one of my proudest achievements as well.
Yeah.
So you've been also a part of a lot of really instrumental appellate cases. What's one of your favorites?
Well, so for a while, when I started practicing family law, and that I did not start family law at the beginning, but after 4 or 5 years, I started practicing mostly family law. And for a while, I argued all my own appeals, and there were some very significant appeals that I took, that I prevailed on, fortunately, up to the 3rd District. But my most notable was the Schutz versus Schutz case, which was a case which, ironically, of all the cases I've ever had, I never got paid. Well, a lot I never got paid. I never was paid 1 penny in the case. And I took it all the way to the Florida Supreme Court. That was the alienation case, of course. And I'll never forget when I went to argue with the Florida Supreme Court. And I'm thinking, oh my God, I'm a guy from Paterson, New Jersey, and I'm going to be arguing at the Florida Supreme Court. And back then, there were maybe one, maybe two, maybe, I don't even know one, family case that would be argued a year. There were so few cases back then that were entertained by the Supreme Court. And I went up there and I'm looking at the 9 justices and I'm going, what am I doing here? And I started my presentation and it took me like 10 seconds to get the stuttering away. And then I made the presentation and then I left and I went back home and I just said, whatever the ruling, this was the experience of a lifetime. And it was, and Cynthia Green was on the other side, and it was just a fantastic opportunity. And and then after that, I stopped doing appeals, but until then, I was doing quite a few.
Did you have an important mentor that guided you early in your career?
Yes, not necessarily in family law, but my first firm that I worked for out of law school, when I got out in 1974, there was a recession. And I wanted to do real estate, corporate, and probate, believe it or not. Because I'm a type A personality, which, Eddie, I'm sure you never noticed, but I'm a type A personality. And I thought it would kill me by my 30s. I'd have a heart attack. So I thought I'd do real estate, corporate, and probate. But every time I went for an interview, they said, you should do trial law, trial work. And I said, but I'll have a heart attack in my 30s. So they said, well, that's what you should do. So my first firm that I worked for was called Adams, George, Wood, Lee, Schulte, and Thompson, which was an all-line insurance defense firm. So the person who I worked for, his name is Charlie George, who's still around, but he's not practicing anymore. And Charlie George was my mentor. He was a superb guy. And years later, when he had marital issues, and I represented him, and he went to pay me, I said, Charlie, you were my mentor. How do I ever bill you and take money from the guy who taught me how to practice law? And the other one, who sort of had the opposite effect, was Andy Hall, who was a brilliant trial litigator in Florida, unfortunately passed away much too young 2 years ago. And his mentoring to me was basically whatever he did, I tried to do the opposite because his approach was not my approach. But he taught me strategically how to practice law, and he was a great mentor also. So the two of them were very good.
You are known for being a great litigator.
Oh, and also Mel Frumkes and Cutner. Those two also, I watched them. And those two also helped me tremendously.
Well, being a Miami boy, I think Mr. Frumkes would influence anyone down there.
No doubt. And I'm sure wherever he is, he's still influencing people.
And you are known as a great litigator. What tips would you give folks that you see, some younger folks that are coming up and litigating in family court? What advice would you give them to kind of help them out?
Okay, first of all, if it's not too late for them, they really need to get good training with good lawyers to start. I think one of the problems now is that many lawyers coming out of law school do not have appropriate mentoring, and they start practicing law either on their own right out of law school, or they go with some attorney who may do a whole bunch of different things, and then they open up their own practice, and they don't have the experience. And then they're not learning. All they're doing is reinforcing their bad habits as the years go on, and that's not good. I think, number one, you need some good training. Number two, you have to really read the cases. Number three, you need to psychologically watch. You understand that you may have a position that makes sense, but psychologically it doesn't. And you may not want to go into court with a position that really is not going to go anywhere, because the judges all have good memories and they know the good guys and the bad guys. So I think you have to be very, very honest with the judge. And if you're wrong, there's nothing wrong with saying to a court, your client may not like it, but judge, that's a good point, and you may be correct on that one. So I think you have to do that. I think you have to inject a bit of humor, but you have to do it at the right time with the right judge. There's some judges I've tried to provide some humor, and they've almost thrown me in jail for my humor. Others, which is true, by the way, others, one in particular in the middle I was litigating with Dory, who you know, Dory Foster Morales, and the judge just let us keep going. And we're going for like an hour. And I finally said, Judge, I'm leaving. And the judge says, what do you mean you're leaving? I said, it's obvious you're now taking charge of your courtroom. And if that's the case, that's okay. I don't need to be here anymore and continue to go back and forth. I'm leaving. He said, very funny. And I got up and I walked out. And the bailiff went to get me, but I knew the judge and I knew he was okay with that. If I did that with another judge, I would have been in the Dade County stockade. So you have to know your judge. So I think for all the young lawyers, before you start doing stuff like know the judge and don't think that you're better than these judges because they will eat you for breakfast. So just be conscientious, but be very honest and be incredibly ethical. And if your client doesn't accept it, get rid of your client because there are plenty of clients as the years go on. Don't compromise your values.
And I think that's probably the wisest lesson I've learned in my career is letting go of these vampire-like clients. How would you identify someone that's a bad client early on, and what tips would you give someone to handle that relationship?
Okay, well, that's very interesting. That's a very good question. So at the beginning, it's the honeymoon. It's like a first date. They all come in, and the guys have shaved. The women have their makeup on. Everybody's soft-spoken, and they just want to be fair. Now, fair is a very relative term. So I think when they first come in, if they immediately appear to be crazy, you need to get rid of them because that's their best they're ever going to be. That's their best day with you. That's their best day. And if they're crazy, get rid of them because they are going to kill you. They'll eat you for breakfast and you will have a horrible time. So that's number one. Number two is this. It's in your presentation. If you tell them what the law is and you say that the assets are going to go 50-50 and they go, well, that's just not acceptable to me. And I go, but wait a second. You have a house worth $800,000. You have $4 million in the bank and it's going to go 50-50 if everything's marital. They go, well, that's not acceptable. Well, where are you going to go with that case? You can't win that case because no matter what you do for them, if the other side gets half, they're going to be angry and go crazy with you. So you have to be really candid with them. And what I try and do is downplay what I'm able to do for them. So even if it's a 50-50, I say, look, it's 50-50, but you've got this good income and maybe she'll get a little bit more, whatever. And if they say, I understand, that's a keeper. But if they say that's not acceptable, as painful as it is, you have to say to them, this is what I think. If you don't agree, you need to interview other lawyers. One woman came to see me, I'll never forget this, like 5 years ago. She was going to get about $30 million. She said to me, what do I get in alimony? I said, you're not going to get any alimony. She says, but no, wait. My husband makes a lot of money. I said, if you get $30 million, you're not getting any alimony. She says, I've seen 9 lawyers. Everyone said I would get alimony. I said, well, guess what? Go with one of them. They're a lot smarter than I am. So go with them. So she picked somebody else, and of course, she didn't get any alimony because how's she getting alimony with $30 million? Those people, even though the money looks good, you can't say to them, I'll get you alimony because you're just get killed. It's not worth it. Life's just too short.
Got to manage expectations and get rid of toxic clients.
Yep. And you know what? And it makes it more enjoyable to practice when you have people who are listening to you or their expectations are realistic. Because if you're talking about stress, the stress comes on trying to deliver for somebody something that you can't deliver. So don't do it. But, again, a lot of lawyers, I understand, need the money. They need to pay their overhead, which is very high. They've got to pay their secretaries. And they think, let me take this case and I'll convince the client to mellow. Good luck. It's not going to happen.
We have been in some very divisive times. It seems like there's a lot of negative energy going around the country and the world at the moment. What advice would you give people just to calm down?
Look, we're in a very tough profession. We are not appreciated by most people. They think they know more than we do. And I just think that the most important thing for us in the practice of law is to not compromise our ideals our ethics, to maintain a sense of humor, which we should all do, but also trying to work with other lawyers. It's because there's just too much adversity. And I see now, maybe because of the virus, it's very hard to work with a lot of lawyers. A lot of lawyers who I'm dealing with, it's just very difficult. And lawyers should get together and work things out if they can. And if you have to try a case, look, we've all tried them. You've tried a ton, I've tried a ton of cases, but that's the last resort. We don't want to go in and say, we want to try a case. That's the last resort. So I just think you have to be yourself and not tell people what they want to hear, but tell them the right things and go from there.
Well, Andy, thank you so much for sharing your wisdom with us today.
Thank you, Eddie, for having me. I'm honored, and I wish everybody the very best out there. And stay safe, everyone. Take care. Bye-bye.
And that concludes October's edition of Stephen Squibs Family Law CLE. We hope you enjoyed it, and please join us again next month.
Thank you for joining us for this month's edition of Stephen Squibs Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.